What you're about to hear are audio files that come straight from a hearing in a class action lawsuit, Hepting versus AT&T. It's a case that involves total information awareness. The allegation that the government is spying on our email, our web habits, our telephone calls, listening in, watching, Big Brother. But there's another issue at stake as well. It's whether we have the right to sue the government when they are abusing us in this kind of way, or whether we have to accept the idea that there are state secrets that we're just not allowed to know, and that such spying may continue unhindered without any kind of control for the sake of national security, homeland security. Listen in and see what you think. These are just the highlights. The full audio file is available at the Ninth Circuit Court of Appeals.
Let me just harken back to my lawyer days, and I could see a very simple document request. It would run something like this. To AT&T, produce any agreement, document or otherwise, between AT&T and the government with respect to listening to domestic phone calls without court approval. I would simply mimic President Bush's words. And presumably, taking President Bush at his word, AT&T's response would be, no such document exists, correct?
I assume that would be the response. I have no idea actually what is going on, but I assume that would be the response to that question.
Let's hope
it's
that.
It's a state secret. I have no idea what AT&T is.
How would it be a state secret if there were no document that authorized AT&T to listen to domestic phone calls without court approval? Now, if there were such a document, then maybe you'd have to say state secret. But if there is no such document, and AT&T doesn't do anything more than President Bush says, wouldn't that be the end of it? And if the plaintiffs wanted more information, then maybe you'd get into the state secret. But why couldn't AT&T say whether it has this document in its possession, which is an agreement to listen without court approval?
The President has said, with respect to widespread domestic telecommunications interceptions, that's not happening. How would it impact any relationship AT&T might have with the government or implicate state secrets if that's the case?
But why couldn't AT&T say whether it has this document in its possession, which is an agreement to listen without court approval?
Because any sort of probing into what, if anything, AT&T is doing for the government has been designated as a state secret.
Even if it doesn't exist? It's a state secret that it doesn't exist?
Well, it might be a good PR move, huh?
Sorry, Your Honor?
It might be helpful in assuring the public that what is alleged in part in this complaint, widespread dragnet domestic interception of private telephone conversations, is in fact not occurring.
Well, the President has already issued a denial that is occurring. Plaintiffs obviously are not satisfied with that. They've presented
no
materials.
court in the land would be satisfied with a public statement by anyone, be it the President of the United States or the President of AT&T or the custodian of the air conditioner in that room on Folsom Street. What would be required would become some kind of affidavit, right?
Well, as I say, I leave it to the government whether they'd be satisfied with that approach. Certainly AT&T would be very happy to have the case end on the...
If one actually fairly looks at the evidence itself rather than the characterization of the evidence, we see some very specific points which we believe clearly establish our claims. There's a splitter cabinet on the 7th floor at 611 Folsom Street. Mr. Klein declares that under penalty of perjury. How does he know that? He knows it because It was his job, as he tells us in paragraph 15 of his declaration, to oversee the room where the splitter cabinet is installed. He tells us in paragraph 36 that he personally installed the circuits in the splitter cabinet. And what does it do? Mr. Klein tells us. The splitter cabinet splits a fiber optic signal. And what happens next? He provides an exhibit, the exhibit is under seal, so I cannot quote from the exhibit. It is under seal because AT&T is contended it's proprietary, but it is described in the Klein Declaration, which is in the public record. And what the splitter cabinet does is it sends the light signal from the 7th floor on Folsom Street to the 6th floor, where the SG3, that stands for Study Group 3, secure room is located. How do we know that? He attaches Exhibit C to his declaration. Exhibit C provides, and I can't quote it again, it's under seal, but it's described, the manner in which these connections are made.
This Protect America Act of 2007, what effect does that all have on this case?
Well, Your Honor, plaintiffs have brought a FISA claim, so ultimately in the litigation of that claim, the court would have to view the recent amendments, particularly with respect to any prospective relief. But fundamentally, we don't think that any of their claims can be litigated without getting into matters protected by the state's secrets.
I guess my only question or comment on your final remark is that we have a denial here of broad spread domestic surveillance. But if we didn't have a denial, and if the government were undertaking that, I imagine from your comments that your response would be, no one could litigate that kind of an invasion because of the state secrets doctrine.
Well,
if there were in fact widespread domestic surveillance of American citizens without a warrant, there would be no judicial remedy to challenge that.
Was a warrant obtained in this case?
Your Honor,
you go through the FISA court on this case?
Again, Your Honor, that gets into matters that are protected by the state secret.
What I don't understand what the problem is.
The
You
fundamental.
just don't want to say whether this particular matter went through the FISA court.
Can you say that without, since those are confidential and protected?
I cannot. The plaintiffs in this case allege that there is a secret room at AT&T, and that alleged activities are taking place in that room.
Well, who decides whether something's a state secret or not? Are you saying the courts are to rubber stamp the determination that the executive makes that there's a state secret? So we just have to take the word of the members of the executive branch that tell us it's a state secret.
We don't.
That's what you're saying, isn't it?
No, Your Honor. What this court's precedents say is the court has to give the utmost deference to the assertion. And the second part of the court's...
Well, what does utmost deference mean? We just bow to it?
Make clear that when the very subject matter of the action is the existence of a secret espionage relationship with the government, litigation must come to an end.
As I understand, in this case, what the plaintiffs are saying is that AT&T has provided telecommunications information about its subscribers to the government without a warrant.
This seems to me to otherwise put us in the position of being in the trust us category. We don't do it, trust us, and you can't ask us about it.
Let me just ask you this question. These are the things that bother me. I mean, is it the government's position that when our country is engaged in a war, that the power of the executive, when it comes to wiretapping, is unchecked?
It is not, Your Honor. And that's why we're here today.
But what are the checks on it? If we're getting affidavits from folks in the executive branch and we have to take their word for it, what is the check?
Evidence is not allowed to be presented on those questions. What the government is not doing can be a state secret.
But President Bush said they're not doing it, so that can't be a state secret that they're not doing it if AT&T simply confirmed it has no such agreement. I mean, why couldn't the litigation go at least that far and then leave to Judge Walker to determine, well, if that's the end of the road or not the end of the road?
So the bottom line here is that once the executive declares that certain activity is a state secret, that's the end of it.
It's not.
No cases, no litigation, absolute immunity. The king can do no wrong.